A constitutional clash over open justice unfolded in the High Court of Belize today, as the prosecutor and a defense attorney advanced sharply different arguments on whether the sexual assault trial of attorney and public figure Orson Elrington should be held behind closed doors. Before the trial could begin, Justice Nigel Pilgrim signaled an intention to close the courtroom. The Crown raised no objection, but the defense objected, warning that secrecy would undermine not only Elrington's right to a fair hearing, but also public confidence in the process. The Crown anchored its position in Section 6(9)(a) of the Constitution, arguing that publicity would harm the interests of justice because witnesses are expected to recount intimate, traumatic details capable of identifying the complainant. DPP Sherlyn Vidal said the defense's insistence on public scrutiny amounted to conducting a trial within the courtroom and one by the public through the media. She maintained that exposing the complainant's private life would risk re-traumatization and degrade the quality of her evidence. The court, she argued, has a constitutional discretion and responsibility to protect vulnerable witnesses. The defense countered with equal force. Senior counsel Wilfred Sede Elrington described open justice as a strong constitutional presumption rooted in common law tradition and affirmed repeatedly by courts across the Commonwealth. He warned that closing the courtroom would create a dangerous imbalance. The allegations have already been publicly aired, damaging the defendant's reputation, yet the public would be barred from observing the testing of those allegations through cross-examination. He argued that secrecy would breed suspicion, especially because the accused is a well-known public figure. If the evidence collapses under scrutiny, he said, the public should be allowed to see that for themselves. Otherwise, even an acquittal could leave a permanent stain. While acknowledging the complainant's potential discomfort, defense urged the court to adopt less restrictive alternatives, anonymity orders, screens, or controlled questioning, rather than excluding the public entirely. He emphasized that the constitutional exceptions must be applied narrowly, not treated as a blanket rule for sexual offense cases. Tonight we're asking, how should the senior courts balance the privacy and welfare of complainants with the transparency needed to maintain public trust, especially when the accused's reputation has already been tried in the court of public opinion? Justice Pilgrim's ruling will determine not only this high-profile case, but also the broader expectations of transparency in Belize's justice system. Reporting for News 5, I am Isani Cayetano.